Hey, deserving listeners, today we're going to talk about record keeping. So for you clinicians out there, this will be relevant to you. To you non-clinicians, I don't know if this will be interesting to you, but some of you like to listen to this sort of stuff, so we'll see. We have a special guest on the podcast today to talk about record keeping. Please introduce yourself to Podcast Land, Frances.
Hi, my name is Frances Schopick. I am trained as a counselor as well as an attorney, although today I'm here to speak on these issues for educational purposes.
Yeah. So, Fran, right at the beginning, is there anything that you want to plug where people can find you? Because your service is very important and needed by a lot of clinicians. So how can people find you online?
Thanks, Kirk. Well, I have a website. It's francesschopick.com. That's FrancessSchopick.com. I personally can be reached at FS, my two initials, FS at francesschopick.com. Also, I just want to say to give an idea of my background, that I am an attorney with an extensive background in social work, both private practice as well as agency practice, psychology, and psychiatric research, where I've been on the faculties of two major medical schools on the East Coast. I work, my main work is as an attorney, I work with counselors and DOH, Department of Health licensees, who have complaints against them. I represent them in that complaint process, which is really important. Personally, I think nobody should ever try to represent themselves in a DOH process. I also do risk management talks on such things as record keeping, documentation, subpoenas, how to handle a subpoena, how to testify in a court or at a deposition, understanding family law and how that interfaces with counseling, scope of practice, so that counselors don't act outside their scope of practice and understand how to handle those things. I just also want to say that anything that we talk about here today is just to give a disclaimer that I'm not giving legal advice. I'm not giving any kind of representation. People should not confuse this with representation, legal advice, consultation, supervision, any of that. If they want to speak to me, they're welcome to call me at 425-891-3411 or to email me. I do consultations at no cost. And I think this is a great service that you're providing, so I'm happy to be here. So
what are some of the problems that you see us therapists? You're a lawyer. You probably see all sorts of things that us therapists do, counselors that you roll your eyes at. I don't know. But what are some of the common things that you see us do that you wish you could just say, hey, stop doing that?
Well, the first thing I think is that counselors often don't like record keeping, which I understand. They see it as annoying and burdensome and laborious. But what I try to get people to understand is that it's actually an opportunity for you to create a body of evidence that can be protective of you down the line. So I guess the thing that I see most commonly is that people avoid doing the record keeping. They do a poor job at doing the record keeping, and that they're in fact squandering an opportunity to protect themselves.
Yeah. So music to my ears. I was, as a supervisor, because I've as 20 plus years as a therapist myself, I've gone through the different progression, and later in my career finally kind of arrived to that place of I actually enjoy taking notes because I sleep better at night.
Yeah, there you go.
Knowing that if anything happens, which is rare, but if it did, I will gladly hand over my file and not have any or have very little worries, in terms of making sure that the file that it looks competent and to the standard of practice, but also make sure that the things that come up, like, for example, if someone was thinking about suicide and then they attempted or, God forbid, even completed,
right,
and the file is pulled, I know that I will have had a record that I did my responsibility. But the thing that I find as a supervisor for trainees and even post-grad, recently graduated supervisees of mine, they haven't been trained enough, so they're terrified.
Right.
They bump up against this, you and me saying, make sure your file's looking good, you should enjoy taking your notes, and and then they're like, okay, and then they sit down to do it, and I think this voice creeps in there of just like, you don't know what you're doing, you sound like an idiot when you write your notes, or something gets in the way, and then they just like, well, I'll do it later or something. Do you find that to be true?
Yeah, a big question that people have is that they always want to know how much to write and what to write. And I think that that's what keeps them from fulfilling the task, because they're concerned from the start, how much do I do? What do I do? There are two schools of thought. One is that, I'm sure you've heard this, one is that people will say, if you didn't write it down, it didn't happen, which leads to copious notes where people feel that they're almost writing a journal on the event. And then other people say, silence is golden. Just keep your mouth shut. Don't say anything. And it's true, in a legal setting, if you say too much, it could hang you. It's like you're providing the rope to hang yourself. So I basically feel like it's a middle ground. On the one hand, you absolutely, by law and ethics and clinical needs, you absolutely need to have a note. You cannot have a session, even if the client asks not to, you can't have a session that has no note, unless there's some, maybe the military might have particular rules around that. But in general, you must have a note. So that's clear. Then the question becomes, what should be in it? I would say in general, you really just have to have a note. All that the law says, the WAC in the state of Washington says, is that you have to have a note in addition to certain other bits of material that is sufficient to support responsible clinical practice of the type that you provide. But the question becomes, what's sufficient and what's responsible, and what is your clinical practice? Because some people they're eclectic. They use a lot of different things. But if you begin to understand that if there's no crisis, a SOAP note is perfectly adequate. Subjective, objective assessment and plan, and it can be one line for each piece. But if, as you just mentioned, if there's some threat of suicidality, harm to self or others, abuse of a child, adult, elderly person, or dependent person, that's where you go to town. That's where you need to put really, You need to do a risk assessment, liability assessment. You need to ask certain questions that are very important, and you need to provide a rationale for what you did or didn't do. If you decide to make a call, if you decide not to make a call, you want to provide a rationale for that. And then you've covered yourself.
Yeah, and I think a big part of it for me was learning real examples of when people are successfully sued or their license is sanctioned in some way because of something that they did that was related to their notes. And learning from that, I then learned, these set, because when you're just starting out, like you said, people tend to write journals, pages and pages. I did this too. I remember back in the day in the 90s, there weren't computers at agencies, and so we hand wrote our notes. And I remember handwriting 2 pages of notes for one session. And because one, I think I was told that I needed to, if you didn't document, it didn't happen. But also I felt like I needed to justify what I was doing to everyone. And my supervisor immediately said, you're going to have 20, 30 sessions a week. I need to sign all these notes. I don't have time to read all. You only need like 1 or 2 sentences here. Please reduce it. Anyway, so I think that learning about the kinds of things that can happen to us, and then we work ourselves backwards to figuring out the kinds of, obviously our notes are also to help us with treatment, right? That's the main purpose. But another purpose is to make sure that we're covering our liability. And so what sort of end result situations do you see as a lawyer that compel us to make sure that our notes are good leading up to that? Right.
So good question. So there are generally speaking, there are 2 types of actions that can occur. One is to be sued. That's a liability claim or a lawsuit. And that goes through the judicial system. That would go through the superior court. That's where someone says that you had an obligation, a duty to me, you breached that duty. Only because you breached that duty did I have a problem, or did you do damage? Did I experience this damage? And then I can show what the damages were. So that's a lawsuit. But what's more likely to happen is, as you also mentioned, is a complaint against your license. and that goes through the administrative law system. That goes through the Department of Health. That's much more likely to occur for several reasons. Main points being that if a person, well, the main points being that, first of all, for a person to file a lawsuit, they actually have to have had a relationship with you. You have to have had a duty to them. You have a responsibility to them. So that narrows down the field. And then also they'd have to show damages. They'd have to have what's called a good case, right? So if they go to a lawyer, the lawyer's going to say, well, what's the case? And is it a good case? And what's the likelihood of winning? And there's going to be a lot of investigation involved, that sort of thing. So that in that case of a lawsuit, even if you wanted to file a lawsuit, the lawyer would probably say to you, let's first file with the Department of Health. Because if they have a finding against you, then that will help our case. That will lay a foundation for our case. Also, the Department of Health will do an investigation, which will be at no cost to you. It'll be done by the Department of Health. So that's another reason it's more likely to have it's more likely that if you were to file a lawsuit, you'd first do the Department of Health complaint. Also, the Department of Health complaint can be filed by anybody. So a person could be standing in the supermarket in the checkout line and overhear somebody else talk about you as a therapist, and they could say, I'm going to file a complaint. Even though the person who goes to you, your actual client, loves you and thinks that what you did was creative and wonderful, the person in the supermarket line might disagree, and they could file a complaint. If the complaint sounds like, if true, it would pose a risk to the public, the Department of Health is likely to look into it because they're all about protecting the public. So that's another reason that it's more likely to have the Department of Health complaint. I have a whole thing about insurance. I always encourage people to get insurance because they often think they have insurance to protect their license, but they don't. So that's a different talk, really. But people will say, I'll say to them, do you have insurance to protect your license? They'll say, oh yeah, I've got lots of insurance, $1 million. And see, that's the lawsuit thing. And sometimes you need to pay extra to make sure that your license is covered.
Yeah, I recently was aware of this and paranoid or freaked out and called my insurance people, and they said I had it. It was
That's good.
Part of the thing.
Good.
But yeah, I never knew that there was this distinction between that. I mean, because to me, yeah, right, a licensing complaint is much more likely, or at least if you are sued, then it'll be a component of it. And I've actually been expert witness on some of these cases and found them to be extremely frustrating to the counselors involved because, one, it's scary to have your practice scrutinized by lawyers and other sorts of people, but also because the state sometimes has different points of view on what we're supposed to be doing than what some of us might believe to be true.
Right. Well, see, that's another really important point, because I find, first of all, as a group, I find counselors to be extremely responsible and ethical and caring.
Almost paranoid. Like they're almost to a fault on some level.
Yeah, I would say anxious. They can be very anxious as a group, which is actually a sign of a sense of responsibility and self-examination. They don't just blame other people. They ask, what have I done?
Right.
But also, counselors all have an imperative to care about their clients, to care about their patients, and unconditional positive regard is one of the statements. And they often mistake that to think, I think, that they often mistake that to think that means that they have a certain assumption, for instance, that a client is always telling the truth, or that there's factually, I mean. And I think there's a difference between fact and truth. A person might be saying what's their emotional truth, but factually, sometimes there are distortions. So when a client comes to a counselor and says something like, my husband's a bum, my husband's an alcoholic bum, he never plays with the kids, and, he's a bad father, the counselor needs to be very careful not to write down in their notes that the husband is an alcoholic bum who never plays with the kids and doesn't care and is a terrible father. You can say client reports that husband is an alcoholic bum. You can say client reports, quote, the husband is an alcoholic bum. But you do not want to be making a statement that as if it were a fact when you have absolutely no idea.
So if that goes to court, there's a custody battle, and the counselors file is subpoenaed, or the counselor is just asked to testify, which sometimes happens, and the counselor submits a report or even gets on the stand and says, yeah, from my understanding, this husband is a bum and drinks too much and is a bad father.
Yeah.
So obviously not a advisable action and biased and not proper assessment procedure. And because ethically you can't be treating someone and assess them in that way. What are the consequences? Because I run into this, people will come to me, supervisees and other people, and they'll say, oh, well, I really love this client of mine, it's his mother, and boy, her ex-husband is quite a piece of work. And, maybe he is. Yeah. But who knows? And, and the counselor's therapist laying out this case and, and they're going to court and we got to keep these kids away from this father, because it's just a bad thing. Again, could be true, might not be true. It's hard to know. And you feel for the kids if it is true. And they're saying, okay, well, the mother, my client, is asking me to submit a report. And I'm always like, whoa, and I go over the ethics and, the possible distortions that you're having and everything in your role as a treating counselor and therapist. But it would help me if I had you to tell me so I could tell them what could happen to them if they actually did submit something and it was either not true or it was found to be unfounded in court. What would happen to a counselor in that situation?
Well, first of all, you alluded to very correctly to the idea of scope of practice, that a counselor needs to understand what their role is. They need to understand who's their client, what's their role, and what's the goal of treatment. So, and whatever they do should be within those parameters. If the person goes to court, or if the counselor is asked to write a letter, often clients will say, if you would just write a letter to my lawyer, it's not a legal document. Or the lawyer will write something. It won't be a legal document. It's like, please, anything that you write that's for legal purposes becomes a legal document. It becomes evidence within that case. Yeah. So,
no offense, but lawyers are sneaky.
They can be. Well, what happens is that lawyers feel that they have this imperative to do everything that they need to do on behalf of their client. Yeah. And so sometimes in that situation, they might say to somebody, I'm here to protect my client. I'm not your lawyer. I'm just trying to get what I need for their client. So I personally am not going to use the word sneaky, but I understand that sometimes people feel misled because they feel that they think that the lawyer is there for them, and they're actually not. And that's another piece that's important, is for counselors to understand that their client's lawyer is not acting on the counselor's behalf, in part because it's not their responsibility to, but also because they have no idea of what a counselor's responsibilities are. A lawyer, let's say a family law lawyer, may not really understand what the counselor's parameters are and what their scope of practice is. So they really can't be there for you. And that's why it really is important for you to have somebody to talk to.
Yeah, that's interesting. So they're probably just thinking, well, yeah, it's a witness that can speak to the thing on trial. They have some data that will back us up. And the impression I also get is some lawyers think that the word of a professional counselor will have a lot of weight compared to just the account of the parent, which is kind of funny because it's like, well, the counselor is only getting their information from one of the parents, but somehow they think like an official counselor word will be somehow heard more. And is that true?
I think they do sometimes think who better to get an opinion from than the counselor. Yeah. The problem is so this now also reaches into another piece, which is the language of the court. So well, there are a couple of things. So first of all, the counselor might be working with a parent, as you're going with your example. The counselor's working with the parent, and the counselor really likes the parent and really believes that the parent is a great parent. And maybe even the child has come into the session and says, I love my mom. I don't want to be with my dad. Maybe they've said that. But that doesn't make it true. It doesn't, you don't know what dynamic is going on, and you don't know what the loyalties are. But let's say it is true. Let's say the husband actually does have certain problems that preclude proper parenting. That still isn't the counselor's job to make that decision or to make that distinction. So I've seen where counselors there are certain words that are terms of art. So a term of art is a word that has special meaning within a certain profession and within a certain context. We have that all the time, for instance, as in a clinical setting, the word paranoid, or schizo. I used to work on a research project with schizophrenia, and I'm always hearing people misuse the term. They'll say the weather is schizophrenic.
Right.
Well, actually, that's not true.
It's not even applicable.
Right. I know, exactly. So people misuse terms. In the general public, someone might say somebody's paranoid, but when you're speaking clinically, that's got very specific meaning. So in the law, and in a context like what we're describing, such as we're describing, words like recommend or an evaluation or an opinion, those words have very special meaning. They mean if you offer an opinion, that suggests that, unless it's within the clinical context, that suggests that you are acting as an expert witness. Or if you use the word recommendation, that means that you've done a neutral evaluation and this is what you've come up with. But as a therapist, you're not even supposed to be neutral. You're not neutral. You're there for your client and you're listening to your client's point of view. So you've put yourself in a dual role. You've created a kind of forensic, you start out with the therapeutic role, the clinical role, and then you, without realizing it, you create a forensic role. And then that's a dual role. So you were asking what might happen. What might happen is that somebody would get upset with you, such as the other parent who is, who your client called an alcoholic bum, and they could file a DOH complaint against you, and you would have been guilty of unprofessional conduct insofar as you've created a dual role that caused harm.
So you wouldn't be lumped in with the civil case or something. It would be a DOH complaint and a license sanction of some sort, either removal or probation or more supervision or that kind of stuff.
Right. The DOH has a schedule of things. There's tier A, tier B, tier C. You can see it online, and it talks about what the qualifications are to fulfill those criteria, and then on that basis that they might have certain sanctions.
Right. Interesting. Okay. So one question I have is that in a lot of people's disclosure statements, going back to the beginning of my time in the 90s when I first started to develop my own disclosure statements, I would see this clause at the end that would say, if you sign here, you're saying you don't want me to take any notes. You don't want me to keep any progress notes other than, the bare minimum, the date, the time, the charge, this kind of thing. And a lot of counselors, if you've seen this before, will, if you have this in your disclosure statement, you like this because it means you don't have to do any paperwork. Because if, essentially you're asking your client, if you want, you can opt for an option where you ask me as the counselor to not have to take any notes because you don't want any detailed record of this treatment. And that is your option. And then the client says, yeah, it sounds good. I don't want a detailed record of my therapy. And they say, yes, please don't keep any notes. Is that legal?
In the state of Washington, you absolutely must have a note. You have to have a note. It has to include certain things which are listed in a WAC. They have to include, for instance, the person's name and certain identifying information, down to the point, and it might include, certain information. It's one of the WACs. It's WAC, I believe it's 246-809-035, I think. So it's on record keeping. And
what did you say, 246?
246-809-035.
Wow, what a memory on you.
It's record keeping and retention, I think.
Yeah, you're right. My God.
Woo-hoo.
Okay, so let's look here. Client name, fee arrangement, dates of counseling, disclosure statement, signed and date. Okay, the written request for no treatment records to be kept. And that looks like it's it. Wait, no, up at top. Fee, date, disclosure, presenting problem, purpose or diagnosis. So presenting problem, purpose or diagnosis, notation and results from formal consults, and progress notes sufficient to support responsible clinical practice for the type of theoretical orientation therapy that they use. So progress notes sufficient to support responsible clinical practice, so that there needs to be something in there.
Well, so then if you read further down, it says that the person can opt out, but they still have to have up to a certain point.
Right. Let's see. But it doesn't, if I'm skimming this kind of, but it doesn't look like, okay, well, let's just read it. It just says those four things: the name, the fee arrangement, the date, and the disclosure statement. And
the fact that they've asked not to have a...
Right.
Right. So there has to be something. You cannot just have nothing there. I believe there might be some exception to that. If there's in the military, some people make an exception. But for what most counselors are doing, you have to have something that shows that you weren't just kind of sitting around shooting the breeze. You know what I mean? That it was However...
But there's an allowance for like extremely sparse notes if the client requests that.
But that doesn't mean that you have to agree.
Right.
And so my question as your attorney would be, why would you agree to this? Because you would be agreeing to sit in a room alone with somebody who has certain expectations of you that may or may not be realistic, who could file a complaint against you, in which case, if they did, you would have nothing to prove your version of events.
Interesting.
So why would you do that?
Right. So I think the implication that people have when they see this option as counselors, they will say, oh, well, so if anything ever comes up that I need notes for, I'll just say, well, they opted out of notes. So
right.
I'm exempt from this, from the need to demonstrate that I did the standard of practice. But that's not true.
No, it's not true at all. I mean, there are a few what I call myths about record keeping. And that would be one of them. Some of the myths are, for instance, that people think, well, counselors will often put other people's needs first, as opposed to, later we're going to be talking about narcissism, as opposed to those people. So, but counselors will often put other people's needs first. And so they'll think that whatever the client wants is what they should do, and to protect the client's confidentiality without thought to the further, sequelae of what could occur. So some of the myths are that if I don't keep note, that if the client asks not to have a note, that I shouldn't have a note. Or another myth is that if I don't keep a note, and if there were a DOH complaint, I would be forgiven. That the DOH couldn't follow up on the complaint because I don't have notes. That's absolutely not true. If you don't have notes, you're out of luck.
Right.
Because they will pursue it. I've had situations where they did pursue it, even though the person didn't have notes. He didn't, and this hits on another myth, is that after a certain amount of time that you should destroy the notes. So this one situation I'm aware of is where somebody, 5 years had passed and it was true that they could get rid of the note. So they got rid of the notes, and then more, 5+ years later, there was a complaint and they had nothing to support their version of events.
Interesting.
There's also, I've heard from some clients where they actually purposefully keep notes that they themselves can't even read. And they think that this insulates them from scrutiny.
Their progress notes they can't read?
They cannot even read their own progress notes. They purposefully, with purpose, they write notes that are illegible, thinking that will both, on the one hand, show that they kept a note, so fulfill that criterion, but will not be illegible, so that they will escape scrutiny. And that's so wrong. It's because
so this is a bastardization of another principle that I think is actually accurate, which is that there's a difference between progress notes and psychotherapy notes, according to HIPAA. So we've been talking about progress notes up until this point. This is the official record in the client's file that the client has access to if they want to pull their file.
Yeah.
We have a thing called psychotherapy notes, which are our own notes. And generally speaking, they're not pulled by clients and other legal procedures. I don't know the words for it, but they tend to just be protected by us. And we can take them at will and destroy them at will. They're just like our own notes that we look at to help us provide the best treatment for the client. Essentially, HIPAA is just like, Well, we don't want to limit clinicians to having every single note that they take available to, certain parties that have access to the file. We want people to be able to write things down. Like I might write, I wonder if this client was sexually abused growing up. I might want to have that question in my own notes, but I don't want to have that in the file because what if the file's pulled and it goes to a court or something and the client doesn't want that question or the details of the sexual abuse. So maybe that's probably more relevant of just
or you could be wrong. The person never did have sexual abuse. It's just your hypothesis.
Right. And or the client says, here are the details of the trauma, and we write a trauma narrative together, and I write some notes down of like step 1, this happened, step 2. And then, the client doesn't want that in the official file, but I need to keep that so that we can have this repetitive, session by session revisiting of those details that can be very therapeutic. So HIPAA allows for that. And sometimes I've heard people say that your psychotherapy notes, you can, if you make them illegible and they happen to be pulled, because I've actually heard of situations where the courts have compelled counselors to actually hand over their psychotherapy notes. It's and lawyers have said, a friend of mine actually went through this, and we were like, well, of course, you don't have to hand over your psychotherapy notes. But the lawyer said, well, yes, it's probable that if we push this, that we could win, but there's a chance we could lose. And it's probably better you just handed them over because things could go bad. So side note, so I'll come back to that in terms of, I want to know what your opinion is about that. But anyway, there's this notion of just like, well, if you make your psychotherapy notes completely illegible, that's up to you because it's just notes for you. And if something happens, you can just be like, I don't even know what that says. And they transferred that, which is probably true for psychotherapy notes because it is just for you. They transferred that principle to progress notes is my guess.
Maybe. I don't know where this person got this idea, but it's wrong-headed for many reasons.
It doesn't make any sense.
Yeah.
I mean, why would there be notes that wasn't even understood by the clinician itself? Like so you just like scribble a bunch of scribbles on a piece of page, and that's like a 3-year-old, and that's your. But anyway, getting back to the question of my colleague, a psychologist who had his. He was doing couple therapy, and the couple saw him taking psychotherapy notes, which is, common enough anyway for therapists to do. And they were going through some kind of difficult, court situation. And one of the lawyers, if not both, were like, we need those psychotherapy notes. I think because at least one of the parties thought it would be damning to the other party, And the psychologist consulted with some lawyers, and he was like, well, of course, we're going to say no, and we'll have an official statement that says no. And the lawyer said, well, yeah, you'll probably win, but you might lose, and we can get ahead of this if you just hand over your psychotherapy notes. What do you think about that?
Well, it's never been tested in the courts. I think it's a really interesting issue, and HIPAA says that they're for you, that they're for your use. It says that if the client, as you already said, if the client does have access to their notes by law, unless you believe that they might cause the person harm, but they do have, generally speaking, they have access to the notes, except for and that does not include the psychotherapy notes. So, I have suggested to some people that if sometimes for the subpoena, it'll just say everything. It'll say progress notes, psychotherapy notes, everything. And you can say to the person, in keeping with HIPAA, I do have psychotherapy notes, but in keeping with HIPAA, I'm not, and the minimum necessary rule, etc., I am not including them here. But then they might come back and say that they want them, and then you're in a situation where you can either fight it or not. It has, to date, to my knowledge, it's never been brought to court, so that question has never been answered.
Yeah, and this is the frustration for me. And when I'm teaching people about this, because there's a rule about a stop sign. There's a very clear rule. You see a stop sign, your car comes to a complete stop before the stop sign, and then you look, and then you can go. The speed limit, 55 and 56, you're breaking the law, and you can get a ticket. You're not likely, but it is breaking. There's a clear numerical understanding. It's very clear. When it comes to our field, there's all these rules out there and, comments and laws and standards of practice. And then there's this thing of like, well, we don't actually know how the court will rule on this. And until they actually rule on it, we won't know what the real rule is. And that seems to be like a reactive rulemaking to, well, now we know what the rule is because the Lord on high judge finally told us, what to do, And of course, judges aren't they don't write laws. They adjudicate laws, right? And they decide, they try to figure things out. But wouldn't it be nice if there was just a law or a rule or something so we knew, because the first person who gets screwed over in this situation is going to suffer quite a bit. And then all of us will benefit from that suffering, but we could prevent at least that first person from suffering by having some clear guideline. And all of us can actually rest assured at night that there was some, clear guidance. When I see a stop sign, I don't go like, well, I don't know how they're going to rule on that, but I've learned to accept that. And as a pro to that, it just sort of demonstrates that we don't actually get sued very often and we don't actually get challenged very often. We're not attacked, so to speak, legally very often. And so thus we don't have that many, opportunities for precedence. The stop sign thing happens every day. And so there's opportunity for refinement of the understanding. But anyway, I'm just venting. Any thoughts on that?
No, I think it's an interesting problem. I will say that people should be aware, counselors should be aware of the fact that even though psychotherapy notes are basically speaking for your purposes, that they could end up being read by other people, and most importantly, or equally importantly, by your client. So there's some people who write notes as a form of venting, and psychotherapy notes as a way of venting, dealing with their own, let's say, countertransference. I hate this client. They always challenge they're always challenging me or my boundaries or whatever. So they might express their feelings, but you should be aware that these notes could show up in a courtroom 2 feet high, being read by a judge and a jury, even a jury possibly, and lots of people, and your client. So in my opinion, they should always be written with care and with respect and with an awareness of that possibility. Yeah,
that's good guidance. We can destroy our psychotherapy notes, correct?
Yeah, that's an interesting question. I mean, in general, I can't really answer that. I mean, it says that the notes are there for you.
It hasn't been tried in court yet.
It hasn't been tried in court yet. I mean, in general, with the mental health record, once you put something in a fixed, tangible form, once you put it down in writing, you can't destroy it. I mean, when it's identified as a note,
you can amend it, you can correct it, but you can't just throw it out and replace it.
Exactly. Unless the time period has passed. And that's another myth, going back to these myths, is that there's another myth that as soon as the time period has passed, for counselors it's 5 years, for psychologists it's 8 years, and then psychologists also have a proviso if it's a child that it has to be either to the age of 22 or 8 years, whichever is longer. But there's the myth that people think that once that time period comes, that you should absolutely get rid of the notes. And that's another thing that I think people should put more thought into, because again, you could be in a situation where you have a client and 5 years pass, so you get rid of the notes, and then 6 years later, the client files a complaint against you, and you have nothing to support your version of events.
Yeah, I have never destroyed any of my private. I've been in private practice for 23 years, and I still have all of my records going back to those early days.
Yeah,
because early on, I remember hearing that. But also, I'm just kind of I don't like to just destroy things. Like I have my journal from when I was 13 years old, that kind of thing. Some people will burn it in some ceremony or something. But I think, well, what's the harm? It doesn't take up that much space in my file cabinet. And what if I need it? Or what if I'm just curious? Or what if a client after 20 years wants to come back to me and I don't remember them, which would be normal, and I want at least some to jog my memory about them in some way. So yeah, that makes a lot of sense. So you can get rid of them, but should you get rid of them is the thing. And so do you recommend people hold on to their files indefinitely?
I generally ask them, let me ask you this. If there were some kind of a problem, would you rather not have the record and tell people that you got rid of it because 5 years had passed and the statute said it was okay, or the WAC said it was okay, or would you prefer to be able to have the note and defend yourself?
Right.
It's up to you. To me, it's a no-brainer.
Right.
I mean, I think especially another thing that can happen a lot is that people with personality disorders, if a counselor works with someone with personality disorders, those people can ultimately be rather quote unquote high conflict, and that might be an example of a person who would whose case would result in some kind of either a DOH complaint or a lawsuit having nothing to do with you or having to do with you. And those people might be people whose records you'd want to keep.
Yeah. I once had a colleague, or I have a colleague, who once told me that he was an expert witness regarding ethics of notes. And I don't know all the details, obviously, because it was secondhand, but a agency was being investigated or sued or something for bad practices. And he was pulled in to evaluate all the record keeping. And
Wow.
one of the things that he found was that there were certain clinicians who had identical notes from week to week.
Oh, yeah.
Across different clients. So,
Oh.
Word for word. What are your thoughts on that?
I think that's very problematic. I mean, that suggests that you're copying and pasting unless for some reason you actually use the same words for every client, and every client had exactly the same problems and issues that you addressed in exactly the same way. So that suggests that you're copying and pasting and that it's not particularized to the client. So
Yeah.
I think that's one of the things that I talk about for people to protect themselves is that if they were audited, that would be I believe that would be considered a problem. It would suggest that they're not actually doing individualized practice.
Right. Not that the note was inaccurate, but it just suggests that you weren't actually, putting in the effort to actually accurately reflect what happened. Having said that, there are certain repetitive statements that I have said over, how many notes have I taken over 23 years? It's thousands or something. And I must have repeated myself because there's only so many options in terms of the general statements, discussed ways to reduce symptoms of anxiety or something, how many times have I said that, or explored history as it relates to current relationship problems or something, there's got to be only a small set of this sort of sentences, particularly if you kind of get in a habit of wording things in a particular way. Not that my notes look identical week to week, but I imagine there would be significant overlap in some of the sentences. And so what's the thought on that?
Well, overlap, yeah. I mean, as you say, we often say the same things for similar situations. I thought what you were saying is that it's actually an identical, like a copy-paste.
It was identical.
So,
but I wonder sometimes if inadvertently some of my notes are either extremely similar or even identical at times. I see a client for 7 years, it's likely that at least, I feel like I'm confident in my ability to navigate this, but for the listeners and my trainees, because sometimes they try to make every note, if they err on a side, if they want to make every note specifically like in its own voice that reflects exactly what happened in that session. And often what I'm trying to do is bring people more towards a system of similar statements that you use given the scenario of that session. Now you might, and I always say, sprinkle in at least one sentence that you can't have repeated in other instances or is unlikely to have repeated.
Right. So I would say go back to the WAC, which says, that the note should be sufficient to support responsible clinical practice for the type that you provide. So theoretical orientation / therapy that the person provides. So that's really, if you were on the stand or if you were responding to an audit, it would be up to you. The question becomes, do you feel that you can support this as sufficient to, responsible clinical practice of the type that you provide, sufficient to support responsible clinical practice? And if you can, then you can, with honesty, you can look the person in the eye and say that this is what happened. This is what I did. Yes, it's the same as last time, but, often it is the same. Right. Then that would be something that you can do. There more questions would be required. It's not just a kind of cut and paste answer, but but that would be what I would be looking at, is that statute or that whack. But another thing you referenced disclosure forms. So a disclosure form is required by law, and it speaks to what the counselor must disclose to the client so that the client can then make an informed decision about whether the client wishes to be treated. And in so doing, the client gives informed consent. But the state has jurisdiction over the counselor, and that's why the state dictates to the counselor that they have to at least have a disclosure form. And then there are some pieces of information that the state says the counselor must include. In my opinion, now this is another thing. People will come to me and they'll say, do I really have to have a disclosure form? And does it really have to be this long? Well, the answer is yes, you do have to have a disclosure form. As to the length, that's up to you. People seem to associate lengthy disclosure forms as being obnoxious or annoying. And short disclosure forms are nice and tidy.
Yeah.
I would say, okay, but does the short disclosure form protect you? Does it convey the information that you need to have conveyed? So in my judgment...
Yeah, just a side note on that. I don't understand that preference. I'm like you.
Yeah.
My disclosure form is quite long. And I've found this in other arenas too with counselors where, like at my university, I wanted to develop a really good student handbook that laid out all the expectations similar to a disclosure form in some ways. And I was getting pushback from people because it was to make it sufficient, the handbook had to be much larger because it needed to include a lot of things that were just basically rattling around in professors' heads. And I was like, you need to write it down so people can reference it. And I was getting all this pushback of just like, geez, this is long, and I'm like, well, it's not wordy. It's as long as it has to be. Like to exclude, X, Y, and Z would be, I think, irresponsible. And I think it's similar for a disclosure statement. And yeah, I just don't understand that sentiment. And back in the day, in the 90s, I remember there were disclosure statements that were fit on one side of one page.
Yeah.
And that cannot be sufficient because there's just too many things to disclose.
I mean, I think that a disclosure form is the single most important risk management tool that you have at your disposal. It's your opportunity to be transparent. It's your opportunity to let the client know that you've thought about what they need. It's your opportunity to say what you need for yourself. It's your opportunity to be clear about the type of services that you can and can't provide. It's your opportunity to provide information about confidentiality, and its limits, which there are many of. There are many limits to confidentiality.
Detailed, they're quite specific, and there's more than people realize.
Right.
Yeah, and for me, I've often used my disclosure statement, I think in the past, because I would develop it with experts and really make sure it was all buttoned up and as concise as possible, but as wordy as it needs to be. And then at times I would be like, wait, what are my responsibilities? And I would go to my disclosure statement and remind myself as to what I needed to do because I knew I had vetted this for public use.
Right.
And so that's another use, I think, of the disclosure statement for a lot of counselors who aren't experts like you, to remind themselves, oh, yeah, that's right, because I developed this 5 years ago with an expert, and this reminds me what I'm supposed to be doing.
Yeah, and it can have your responsibilities and the client's rights and responsibilities. But in addition to, so the HIPAA Notice of Privacy Practice, that's pretty much a prescribed form. And that's why I think at the end, really the client is the only one who needs to sign or acknowledge. You don't have to sign a HIPAA form. But the disclosure form, by law in the state of Washington, both people have to sign and date. If it's not signed and dated by both people, it's not valid. And so the state disclosure form is your opportunity to have what the state requires, but also to tailor it to your practice. So for instance, if you have a practice that involves touch, like, let's say you do pain management, and part of what you do for that pain management is you teach people to breathe deeply. And you might need to point out how to breathe. Most people don't know how to breathe deeply. They don't know anything about the diaphragm. And so you might the impulse might be to touch them in the lower back to show how deeply they can breathe. That touch is a very charged issue. A lot of people, particularly if there's been sexual abuse, but under any circumstances, people might feel molested if you've only just touched them. I might in general recommend not to touch people. For the purpose I just described, you could use a pencil to put toward the person so that they can feel where to breathe. But anyway, the point being that if that's something you do, then you put it in your disclosure form. You say, this is one of the things that I do in order to promote pain management skills. And if this isn't okay, please tell me. It's your responsibility to let me know in writing. I'm absolutely happy to know that. There are also things about legal services. People will say, I don't go to court. But what if you do have to go to court? What if you're subpoenaed to go to court? I think it's advisable to say, if you want to, you can say, in general, I don't go to court. But if I have to, here's how much I charge. Because sometimes you might need to pay, you might need to charge money for preparation, or writing a letter. It's not part of the actual clinical service in session, but you spend your time doing it and you might want to be paid. So, but if you don't put it in your disclosure form, the person might feel blindsided that now all of a sudden they've got an extra bill of $500 that they weren't expecting to have to spend. So, all secrets is another one, particularly if you're working with couples, how you deal with secrets. Some people take walks with their clients and what might happen there, or sometimes people have a pet in the room or they allow their client to bring in a pet. There are all sorts of things that can be addressed easily enough. Dual relationships, romantic relationships, financial relationships. It's easy enough at the start to say, I do not engage in dual roles and I'm not going to have a personal relationship. We're not going to go to the movies. I mean, you don't have to put those words in, but to have that discussion at first, because later on, if it comes up, it can be a difficult subject to address. And but if you have it in the disclosure form, it's all there, and you can easily say, I don't know if you remember, but we discussed this already. Risks or benefits of therapy, no guarantees. These are all things that are not dictated by the law, but I believe could be well advised to include.
Right. Not only is it helpful for people to be informed, as you're saying, and it's also therapeutic, I think, to say, look, I treat all my clients this way, and here's proof that I treat all my clients this way. It's in the disclosure form.
Right. This
isn't personal to you.
Right.
I'm not refusing your friendship because I don't like you. It's in my disclosure statement. I don't do this for anyone.
Right.
I think that helps to, especially if someone has issues with boundaries and they probably have some traumas around rejection and that sort of thing. And so you want to do all you can.
Right.
Do you like, as much as I do, hearing about cases where people get sued?
Well, I mean, my heart goes out to them, and I know it's difficult.
But they're frequently so egregiously, the behavior is just so bad, the comedy of errors that these people do. When I review these, my insurance company will send me cases, I think as a way of educating us with what not to do, of successful cases that have been, gone to court for civil cases or licensure. And I'll read them on the podcast and as a cautionary tale, as a tale for me to learn from. But also, I don't know, there's just something, it's like a Law and Order episode or something. There's just, I don't know what it is. Do you get any pleasure?
Well, I do read them. Yeah. I get notifications from the DOH and they'll say if there's been an action taken, and I will look up the case and read it.
How do you look up the case?
You go on the DOH website and it'll say healthcare provider, search for healthcare provider. And if you know the person's name, which will have been in the announcement, you can see exactly what happened. I mean, it's not the full account. If you want the full account, you can go to PDRC, the Public Records Division, and at the DOH, and you can request it. But that can take, anybody can request it, but that can take months, but you can get it.
Does that cost money?
Yeah, you might have to pay for it. It's like 10 cents a page, I think.
Okay.
Yeah.
How do I get on that email for the DOH announcements?
I don't know. I sort of stumbled upon it, but you basically go to the DOH and there's at some point you can come up with something. I can send you.
Yeah, please.
I'll send it to you.
Like I said, there's something about it. Like, again, I feel bad for them too. But at the same time, these cases often involve behavior that, to me, I think they should have known better, or at least they should have intuited. They should have consulted with someone at some point, and they never do.
And that's the thing I try to impress upon people when I do presentations, risk management presentations on record keeping or dual roles or what to do if you get a subpoena and DOH complaints. So I do these talks and I tell people, if there's one thing that you come away with It's just to get a sense of what might be a legal issue, and that if something might be a legal issue, they should pick up the phone and call.
Right.
And so, I mean, I do a free consultation. I'm happy to speak to people.
How do people contact you?
They can either email me at fs@francisschopick.com, or they can call me at 425-891-3411. I'm happy to receive calls.
Great. So I'll ask you we'll put that at the end if you didn't get that down. So we'll get that a repeat later on. That's a wonderful service that you're offering.
I think so. And the reason I do it is because I believe that a person should have a lawyer before they need a lawyer. So, I mean, if you actually need a lawyer, if you get a DOH complaint, one thing you might do, which is reasonable, is to call your insurance company and see if they have somebody to suggest. And they might, or
your professional organization.
Your professional organization, yeah. And I think I know it's rare just in the state to have somebody who is both a lawyer and who understands what clinical practice is all about.
Right.
For me, having had experience as a therapist and then a psychiatric researcher at two major medical schools, and I've worked with perpetrators of domestic violence as well as targets or victims of domestic violence. I have been a reunification counselor, that's a whole other story, but I performed that service. I have been a family law attorney, and now I do this work. So I think...
This work meaning legal...
I work with people. I represent counselors or DOH licensees who have complaints from the Department of Health.
Oh.
That's the main focus of what I do. I also help people set up, in order to hopefully risk manage, I help people set up their documentation for practice so that their disclosure forms are not only adequate, but that they really do protect, they really do communicate what the practice is going to be like. I do ethics consultations. I help people if I represent them, or help prepare them if they have to do depositions, or I give advice if they have subpoenas, if they have to testify in court. It's really important to help them understand the language. As I said before about using the word recommendation, just the use of that word I have seen to be very problematic for counselors because it suggests that they are acting in a forensic role. So. Yeah.
I didn't even know that, but it makes total sense to me.
Yeah.
I am trained as a forensic psychologist, but I haven't done the work, so I just have the book knowledge of it and some mild experience with assessing. But so this is all kind of coming back to me.
Yeah, it's not rocket science. It's not impossible to learn. It's just you need to know to do it.
But where? So here's the thing that I want your opinion on. I often hear about people going to ethics courses at various universities, including my own, I'm just going to say this, where people will emerge from what I understand to be misinformation.
Yeah.
And what I will say is, I used to be program director of the couple and family therapy program at Antioch University, Seattle, and I know how the way this works. It's like you're scrambling for an ethics teacher, and you just tap someone who's willing to do it, who you think probably is professional enough to do enough research on it, but you're not sure because you're not an ethics expert necessarily as a program director, and so you can't gauge if this other professor knows more than you do about ethics. So you're like, well, they must know a lot, but they're not guaranteed to know enough to actually be a good source of information. And the thing that I tell people is that in order to really know if what you're being taught is correct or what you're saying is correct, is if you actually have contact with where the decisions are being made, which is in courts and with the state administration people. Mm-hmm. Those are the people that are, regardless of what thoughts we have about what's right and wrong, they're the people who actually make the choice, regardless of our own opinion about it. Mm-hmm. And so the closer you are in contact with those, institutions, the more accurate your advice is going to be because you're going to actually see the way that is. And the further you get away from that, the more likelihood your information is going to drift away from reality and more towards just like your own rumor or your own hopes of the way things should be or something. And a lot of these ethics teachers don't necessarily have experience like you where they're actually in those decision-making, rooms and seeing the way that the state and these other people make these decisions. And that's why you see these bad, this is just me, but my suspicion is 90% of ethics teachers are actually not close enough in contact with what you are in contact with. Do you have any thoughts on that?
I don't know about what most universities are doing with ethics. I do know that a lot of the stuff that I'm trying to teach people, they did not learn in school.
Right.
So, which is, to me, surprising, because it's easy. And as I say, it's easy enough to teach. You just have to know to do it. And for instance, I've heard some people come away from ethics courses saying that they learned, if they get a subpoena, to ignore it.
Right.
Which is terrible.
Right.
I mean, if you get a subpoena...
I was taught that. And then later learned that wasn't true.
Yeah, no.
And because I have someone like you, I have a family therapist / attorney who is a friend of mine, a colleague at Antioch, actually, who doesn't teach at Antioch anymore. And I don't even know if he ever taught ethics, ironically. He taught a lot of family therapy courses. But anyway, whenever I would have questions, I would ask him, and he'd be like, well, and the way he would talk, way he would talk about the way judges and courts and the state actually adjudicates these things, I was like, whoa, that sounds interesting. Like the subpoena thing. It was like, well, you might be able to get away with it, but if you piss them off to a certain extent, the judge can actually just, do certain, I don't even know what, but they can actually do things to you that will be unpleasant. So you want to make sure that you actually, the advice I remember hearing was, if you're trying to avoid a subpoena, you want to kind of work with the courts on that. You don't want to just ignore them. You know what I mean? Like if you're trying to, you can say certain things, like you can sort of test the ground of like, oh, what are you asking me to do? What's the expectation here? And sometimes you can actually get them to realize that you're not actually needed and you're not actually a very helpful, to any side. And that requires a conversation with them, not just blowing them off and ignoring them, which they could consider to be a bother and then dig in their heels and really go after you. You know what I mean?
Would you say that you might let them know you're not needed? I mean, I think often they have unrealistic expectations of what you can do as a therapist, what kind of information you have or what you can provide. So I actually think that's a good point where you can, if you're given permission to speak to the person, to just say, I don't know what you're looking for, but I probably, under the best of circumstances, or under the most disclosive of circumstances, the most you could give are the facts. Just the facts. The person is my client. The person came here on this date. The person canceled on that date. The diagnosis was such and such, and treatment goals were such and such. That's really about it. You can't draw any conclusions. But I think there's a misunderstanding around the subpoena issue. You should not ever do nothing. However, you may not be giving them what they want, but you shouldn't ignore the subpoena. You may not fulfill the subpoena, but you should never ignore it. Right. Another area of confusion is that I've seen people come away from ethics talks where the counselor says that they have privilege, which they don't. They're in a privileged relationship, but the person who holds the privilege is the client. So it's a weird situation where the counselor owes the duty of confidentiality to the client. But if there were an issue around disclosing the record, it's the client who holds privilege over the record. So if you were to call me up and let's say if I were you're the counselor. So I call you up, I'm the lawyer, I call you up as the counselor and I say, I want your client's record. You would first say to me, I can neither confirm nor deny that I even work with this person. But let's say we get past that point and you have the duty of confidentiality to your client. You would want to ask your client if your client intends to assert his or her privilege, because that's when it comes to a legal issue, it's the client who has power over the record. So you hold the record, you're the custodian of the record, but the client has power over the words on the record.
Isn't that just a fancy way of saying it's confidential unless there's a release of information, or am I not understanding?
Well, it's just in terms of you. Sometimes, I mean, that is true, that it's confidential unless there's either a written waiver or an implied waiver, implicit waiver.
So the waiver is the waiving of the privilege, or is that a separate thing?
Yes, they waive their privilege.
Okay.
But it's where the
or they, well, anyway.
But I've seen counselors come away thinking that they hold privilege, and they don't. They need to understand the limitations.
Meaning
of
that if the client says, please hand over your record, the therapist thinks they don't have to?
If somebody comes to the therapist and says, we want the record, the therapist thinks that it's up to them to say yes or no.
Right.
And it's actually up to the therapist to speak to the client and find out what's going on.
Okay.
In the case of a subpoena for mental health record, there is a statute that rules that. And it's a whole process. They have to get a 2-week notice letter, and then which gives the client time to try to get a protective order over the record. And if the client either tries to get a protective order and fails to get a protective order, or if the client simply doesn't try to get a protective order, then after that period, the counselor will have to turn over the record.
Right. And again, for those of you listening, you don't have to remember this.
Right.
You just have to remember this is a situation you need legal counsel
Exactly.
To navigate.
Right. Exactly.
Right.
See, that's my point. If somebody walks away from here and they're thinking, oh my gosh, what was that? Like, I don't want to have to bother with the statutes and that's too complicated for me. That's fine, because really the main point is to know this might be a legal issue. I'm going to call Fran, or I'm going to call a lawyer. I want to talk to somebody about this. Because if you ignore it, you could end up in hot water. But if you take care of it, it might be perfectly simple and it's easy to do. You just want to make a call.
So what are the common DOH complaints that you deal with?
A very common DOH complaint is a dual role, creation of a dual role. And that can often be a sexual dual role where a therapist becomes involved with a client or a former client. More commonly, it's a former client, but it can be a current client. Also, there can be problems around, they often come up around children, actually, custody issues. So the issue itself is one of scope of practice, but it'll come up around working with somebody who wants you to make a recommendation as to custody, or if you're working with a child, the parents kind of fight over the child, and a parent might try to get you to file a CPS report, and if you do that, then the other parent will become enraged. So,
but can't be founded, right? I mean, if we hear something, we got to report it, right?
If you hear something that you have a reasonable cause to believe is problematic, that a child or elderly person or dependent person has been abused, you must report it.
Yeah.
But the person who's being accused or allegedly harmed somebody, they might feel that you were ill-advised in doing it. They might feel that you didn't have a reasonable cause to believe, that it's just another parent who's trying to get back at me, and you listen to them.
So what's the distinction there for us?
See, in the end, it might be dismissed. But the point is that these are the things that enrage people that cause them to file complaints.
Right.
So, and then, even if it's dismissed, as you're well aware, it's horrifying for people. It's humiliating. It's aggravating. If you don't have the right insurance, it's very expensive. And
how expensive?
I shouldn't say very. I mean, it can be thousands of dollars.
Like $20,000?
Could be.
For lawyers?
Yeah.
And experts and whatnot?
I mean, if it goes to a hearing, it'll be much more.
Right.
But just to sort of take care of it all, it could be $10,000. It could be, if it's really easy, it could be less. But
even just to squash a ridiculous, enraged ex-husband who has something wrong with him, and he's just
it can take over a year. So I mean, these things can take a long time. I have one case that hasn't even. We got the first letter that telling the person that a complaint had been filed over a year ago, and it hasn't even gone into the investigation yet.
Wow.
So, but what that means is that now, going into a year, if you have to re-credential with your insurance companies, or you need to re-up your own insurance for your own liability insurance, you now have to report that you're being investigated. Whereas if it could just take a couple of months, then at least you get that heartache off of your chest.
And this is something that, because I've not often as you, I've just a dozen cases or something where I've been called as an expert or consulted or something along these lines, and I've seen enough of them where they don't freak me out very much. I kind of see them, well, your number came up and someone decided to drag you through this process, and now it's time to go through the process. And yes, there are elements of this that are going to be inconvenient, but the biggest consequence to the counselors is the emotional side of just the humiliation that you mentioned, and just the terror and the deep sense of shame that I think all therapists like have just below the surface of, like, I'm going to be called out as a fraud, and everyone will figure out like how stupid I am as a clinician. Do you ever try to help people with that emotional process?
Well, yes. I mean, I try to help people come through this process with their heads held high.
But enduring, though, of just like, okay, we're about to head into this for a year. You're probably going to feel a lot of shame. It's a lot of it is probably not justified in terms of the deep shame and stress that you're going to feel. It's quite normal for these kinds of things to happen. They don't happen to everyone, but try to take it easy on yourself. And worst case scenario, you'll probably have to go into probation. You have to take some extra classes. I don't know if you can advise on that level, predictions and everything, but I don't know. Do you ever try to, because that's what I've tried to do when people have come to me. I've been like, because the gestalt of their, approach to me and communication to me is their desperation and despair, and they're not sleeping at night, and they're crying, and they're like, maybe even suicidal on some level, just because of how earth-shattering this can be to people. But to someone like you who just sees this as a routine thing, it's just like, well, sometimes it's justified, and there should be some tears involved. But as you're saying, you just have an angry father who is waging a complaint because you just did your duty. That counselor shouldn't have to cry themselves to sleep every night, right? I mean, do you ever try to help them with that?
Well, my function is legal, and I always reiterate that I'm not their therapist, but I feel that doesn't keep me from helping them legally in a kind way and in an empathic way. So I do let them know. I don't necessarily say that I expect that they're going to feel shame, but I do tell them that I understand that this is mortifying and can feel humiliating. I let them use the words, and then I can reflect them back. But I certainly let them know that I'm there to help them get through it, not only legally, but also to reflect back to them that this may not be their fault. Now, sometimes there are fairly egregious things that can occur, and I might talk to them about what precipitated it, because sometimes that helps in their narrative as they respond to it. And I often find that it's really important to have people tell their story. First of all, because I find in general, people feel the need to be heard. But also, if a person were to try to respond to this thing on their own, often people will do a whole mea culpa. Oh my God, what was I thinking? Which, I did something wrong when they didn't. And sometimes they might give more of a story than they really need to. They get into other really psychotherapy issues that are not legal issues, and that can actually put them at risk if they say too much, more than is needed. I try to get them to just pay attention to the question, answer the question, and then stop talking. So
one of the situations that I'm dealing with on a daily basis with my supervisees, and I guess in my own practice, is that as a family therapist, I am a couple and family therapist. We treat couples and families and individuals. And our industry and our reimbursement structure and insurance structure is all based on one person. When your son has a broken arm and you bring him into the hospital, they don't open a file for the whole family. They just open a file for the boy with the broken arm. And that's the medical model that we, adopt in our psychotherapy field, which isn't ill-advised in many situations, but doesn't really graft onto the way that family therapists operate. We treat the family system. And although one person might have, quote unquote, a lot of symptoms, we recognize that often the symptoms are a result of the way the system is operating. A very simple example is you have parents who are very stressed out and are having a lot of marital stress, and a teenager who has depression. And you, instead of just singling out the teenager with depression, you think, well, this whole family needs to look at, how their stress level in general, how they're treating each other, the love, the attachment, how stressed this kid is about the parents' relationship, that kind of thing. Anyway, so when my supervisees are at agencies and they're seeing, that teenager comes in to see them, and then they say, okay, parents, come on into the office, let's talk about this. the thing I always say is, before you treat the parents, you have to get informed consent. You can't just like pull them into the office and start treating them. So you have to do the whole gamut that you did with a teenager in terms of, you're a client, here's my approach, here's confidentiality. Do you agree to a family therapy treatment plan, all this kind of stuff. And my question to you is, because I've actually seen cases where counselors will get slammed for not navigating this scenario correctly, so that a client will not be informed that they're a client. A parent won't realize they're a client, and then later down the line something weird happens, and then they want to wage a complaint, and the lawyer says, well, were you ever given informed consent? And I don't know, did you see cases like this ever?
Well, I've read about cases like this because I read these things, and and I've had clients who had prior cases like this. Couples and family work is incredibly, as you're well aware, is incredibly complicated because of the systems involved, and the LMFT Code of Ethics says that when, as opposed to all the other codes of ethics, actually articulates that when they get informed consent, they get informed consent before they'll release a record. They get the consent of every person capable of giving consent. They won't otherwise release the record. So that would include in this state, that would include a 13-year-old child, which is good. You cross over onto so many issues. And again, as I said earlier, you have to know who's your client, what your role is, and what the goals are. So that's really kind of what you're talking about, is knowing who's the client. And that's also that they need to know that they're clients. Mm-hmm. If they're not clients, if they're collaterals, then their hold on privilege, which we just discussed, is affected, and it affects whose signature you need, for instance, to release information. If you start with one client, let's say that family brings the child who's depressed, and the child is your named client, and then you bring in other people, you risk the child feeling that he or she is losing his therapist to the family. And then also you have the insurance issues. Depending on who's the identified patient or the identified client, the insurance is expecting the therapy to be geared toward that person.
Right.
So if you bring in the family in order to enhance the treatment for that one person, then that's fine. But if you then end up in a situation where you're in fact doing family therapy, which is a perfectly wonderful service to provide, but it may not be what the insurance is covering.
Right.
So I've seen threads where counselors are saying, I don't care what the insurance says, my duty is to my client. And even though it's one person in a couple who's using their insurance, and they're really doing couples therapy, they're billing it in a way that is a code that's suggesting that they're treating the individual, not the couple, and they could, that could be fraudulent activity. So there's the insurance issue as well as the clinical issue in what you're describing.
Yeah.
But I have seen situations, DOH cases, where it started out, for instance, with one child in the family, and they brought in other people, and the child felt that she lost her therapist, and that the DOH said that was doing harm, because not only did that child lose her therapist, because she felt she lost her therapist, but it could affect her attitude toward therapy going forward.
Interesting.
And that was a harm that the DOH identified.
So the family therapist didn't get enough informed consent from the client prior to inviting the other members into the room, and didn't document it. That's right. Yeah, just sort of against or without any conversation, essentially just pulled in the parents.
Yes.
Yeah.
And the therapist might have felt that it had good clinical purpose to it to pull in the parents. I mean, right. Generally it does in a situation like that, but it has to be done with consent. Right. And the distinction here is that it started as individual therapy. If it started as family, if, session one, it's everyone. Correct me if I'm wrong. Yeah. And you give informed consent to everyone from minute one, and you're like, I'm a family therapist. This is family therapy. Does everyone consent to that model? Then that wouldn't be as much of a concern, because you never framed it as, and it was never, at least it never looked like individual therapy for the teenager. Right. And then the question becomes whether the insurance pays for that, because usually insurances don't. I mean, and that's also complicated because you can call up an insurance company and speak to the representative on the phone, and they'll look at the code, and it sometimes says something about family, and so then they'll say, yes, this is covered. When in fact, on the deeper level, when it gets higher up in the insurance, it's not covered. Well, so you really need to make sure that it's covered.
Yeah, I mean, someone who's done this, a fair amount, but it's never really been tested, I guess. But the practice that I do and that I tell people to do is there's a code that, because insurance company, like you said, it's geared towards the treatment of one person for a set of diagnoses. And what you do is that, you don't send, my client is the family to the insurance company. You say, my client is this one individual, which is accurate. You're not lying. You're just not mentioning the other clients, I guess. And then you say, I'm treating this person with other people present in the room, which is reimbursable to insurance companies. And it's accurate. It's legit. You're not lying. You're just framing it in a way that is in the language that insurance companies
But are you, in fact, treating this person with other people in the room? Because the question becomes, if the treatment is geared toward this one person and everybody else in the room is there for the benefit of that person's therapy, then that supports what you're saying.
Right.
But if, in fact, you're talking, I mean, there could be good reason to talk about, well, maybe the father's depressed, or maybe the father has difficulties at work, or the mom has difficulties at work, or there's another sibling who's failing at school, or who's in a relationship where there's abuse, so that can affect the person who, for whatever reason, is the identified client.
Right. So
the question becomes whether you're actually looking at the parent's problems because they're part of the system, but you're looking at them for the parent, for the benefit of the parent or sibling, or are you looking at any of those other issues which are sort of adjunctive to the identified patient?
Right. Absolutely.
And your notes should support what you're doing.
Your philosophy should, the notes should support that. And we don't lie. We're not, and that's the whole thing. It's like, there's a legitimate way to do it that isn't lying, that, you're not fraudulent, but you are, speaking in the language of the insurance company, because it's not the way that family therapists speak.
Right.
But it is the way that they operate. And so you just have to word it in a way that, fits the insurance company. Similar to couple therapy. They don't often cover couple therapy, but they will cover individual therapy. And so if one person is diagnosable and has a medically necessary diagnosis, then the insurance company has always been perfectly fine with my, codes of other people happening to be present in the room.
Right. But it should be what you're saying. It should be, in the case you're describing, you should be doing the therapy for that one person, and the other person in the room is there for the benefit of that one person, as opposed to being there for the benefit of the couple. Right.
But it is a potato kind of a thing, like let me give an example. Well, give me two examples. One is where I couldn't and won't bill in that way, and one I will. So one person has been through. Well, okay, I'll change some details, obviously, but there was a gay couple. One of the partners had been cheated on, and had discovered the infidelity rather abruptly, and it was a very particular reaction from this person, that it was a trauma reaction. They had a spike in distress. They had a lot of symptoms afterwards, and so the diagnosis was, I can't remember the exact diagnosis, but it had something to do with trauma, and the treatment of recovering from infidelity was absolutely a discussion with the couple. But I absolutely was focused on reducing the trauma symptoms in the individual, and successfully did that. But many of the conversations were with the couple in the room. Would you say that that's a legitimate case to the insurance company, that was individual therapy with another person in the room?
Well, the other person in the room was there entirely for the benefit of the person identified as the client.
Uh-huh.
So you're not getting into couples issues per se. You're really there for the benefit of the client.
Yeah, but it is a couple issue because the other person was the one who had cheated on.
So depending on how clear it is, you would just need to be, hopefully you'd write a note, back to the documentation issue, you'd write a note that is sufficient to support the responsible clinical practice of the type that you provide, theoretical orientation/therapy that you provide.
And it's disclosed to the clients, and
right,
they
and
understand
it's disclosed.
that.
And, the worst thing, in my opinion, the worst thing you can do with an insurance company is to try to get over. Just be transparent if it comes up.
Right.
But because they could do a clawback, what's called a clawback, they could want all their money back.
Right.
And they could accuse you of fraud. Right. So you don't want that. No, nothing is worth that. It would really depend on how you see it and how you do it, how you perform that therapy. But again, I would just say whoever is identified as the person whose insurance it is, if it's considered individual therapy, it should be for the benefit of that person, as opposed to the benefit of the couple, where the couple comes in and talks about their issues as a couple. So I can't go by the facts that I realize you're giving me a general idea. So with a general idea, I couldn't necessarily, but these are the considerations I would have.
Yeah, it's good for me to kind of mull over because it is a question I get a lot of. And what a common rumor, I guess, is that it's, couple and family therapy just isn't covered at all. And so a lot of people just walk away going, well, I guess I can't use insurance. And that's not the case because in, my 23 years, I've absolutely used insurance and mulled over this question a lot of just like, well, and at times they'll ask me to justify my treatment plan. And I've provided documentation, to that and been able to kind of mull over like, well, am I just making this up or is this legit? And I've come to the conclusion that, in the cases that I've designated as such, that it is totally legit. And I'm not just shoving a round peg into a square hole. It is, but it is just a different way of describing it. And because with my couple and family therapy colleagues, I'm not saying this is individual therapy. I'm not saying even when I'm doing individual therapy, let me put it this way. I have clients who come to me, they're just individual adults. I am treating their whole system, even though I don't have contact with those other individuals, I am thinking systemically. And through that one person, I am, trying to affect that whole system so that they can all meet each other's needs and this sort of thing. And so, yeah, I was just rambling about that. But it is a stress for couple and family therapists, which I find to be just strange because there's a ton of evidence, empirical evidence, that family therapy does work for a lot of things. So why are we excluding, empirically sound treatment plans?
Yeah.
It's just because it's inconvenient or something. But anyway, so my last question for you, because I don't want to take up too much of your time, and is so on Facebook, there's a lot of discussions about ethics. And you mentioned you see Facebook threads, and being friends with Tiff, I'm guessing, you have, I don't know what contact you have with all the different, Tiff has a wide variety of experiences
60 or something.
On Facebook, what I mean? What's something you've seen on Facebook lately that you thought, oh boy?
Yeah, I do know some people who are on 40, 50, 60 Facebook sites, I've heard. I don't do that. I don't have the bandwidth for it. I think it's a huge responsibility as an attorney to go on to a Facebook page and say, I have the answer, because there's so many facts that can be involved. So I don't do that.
Yeah, I have a similar feeling. I browse Reddit all the time, and there are a few subreddits that I follow that have to do with psychotherapy. And people will pose questions on there that are from a layman's perspective. And I definitely have an answer to it. But I just think, like to present myself as a professional who actually answers this question adequately and understands even the question adequately would just require like hours of my day.
Right.
And so I just say,
Yeah.
I hope someone else answers that question because I don't have the time.
Well, and also, first of all, you end up going down a rabbit hole because then they have all sorts of other facts. Secondly, if you elicit those facts, now you're eliciting facts on a public forum that could be problematic really for a client. Thirdly, anything I say, because I'm an attorney, I fear that people will take that to be legal advice when it wasn't. I can't give legal advice if it's when I don't have all the facts, and particularly if I'm not representing somebody, I feel it's not my place. And then there was a last thing that I wanted to say, but it just becomes very, very complicated. And I don't think it's wise for me to put myself in that position.
Yeah, it makes sense. And it's unfortunate, I think, because the average, if not the vast majority of conversations, among therapists regarding ethics are just a string of misinformation and reinforcing the misinformation.
Yeah.
So, Fran, at the end of this episode, is there anything we didn't get to that you feel like you want to make sure we get to?
Thanks for asking. Yes, when we spoke about note keeping, a really nice, concise way to take the note can be that the counselor can comment on something and then just say as evidenced by or as reported by. If they want to say a client appears to be depressed, they say as evidenced by. If a client says that they have some comment on someone else in their family, you put a quote around it. The counselor should not assume it to be the truth or factual, and the counselor should not take that on as their own evidence. It should be as evidenced by and as reported by.
Meaning that you've seen some people document their progress notes where they say, client was depressed today, and that's it.
Right.
Rather than providing evidence that they observed that would, one, bolster their claim that the person was depressed, and also in the case of scrutiny, it wasn't like they just had a sense of something. They were actually using clinical observations to make that conclusion.
Exactly. Whenever someone keeps a note, it's really important to link the observations to the diagnosis. This helps if, hopefully nobody will ever be audited, but if they were to be audited, the counselor would be able to point precisely to the diagnosis, what the symptoms were that led to the diagnosis, and then how those symptoms are reflected throughout the session so that there should be no question about reimbursement.
Yeah, I run into this a lot with my trainees. I think part of it is because they're not trained to do this very well. And it's also kind of a scary thing. It's much easier just to say, yeah, they're depressed, moving on, rather than, oh crap, I have to justify this. And again, it's a matter of training. And the as evidenced by is actually something that I have hammered into my students' head prior to them actually even going to internship. When they do these mock therapy role plays in class, and I will ask them to have a conceptualization of in various, not only diagnosis, but other assessment angles. And I will always hammer on them if they don't provide evidence. If there's, well, this client clearly has a problem, has a complex with their mother or something like that. And I say, as evidenced by, and the people that do that, they get into that rhythm of like, okay, I just made a claim, and now I have to say as evidenced by. It makes it so much more convincing, one, and two, just reflects that you are using competent methods of assessment. You're not just like willy-nilly throwing stuff out there, which honestly, no offense to the clinicians, but I see clinicians doing this sometimes, experienced people will just be like, well, clearly the person has borderline personality disorder or something. And I'll be like, okay, what's the evidence? I'm listening.
Right.
And they'll be like, well, they just have that kind of vibe. And I'm like, oh boy.
Right. And I think one of the reasons for that can be that as a group, therapists are people who are, generally speaking, highly intuitive and picking up on a lot of unspoken signals and body language, things like that. So they've learned throughout their lives to draw certain conclusions, kind of as a protective and adaptive mechanism. But in this context, you're right, in this context, it's really important to be able to give the evidence and further, for good practice, but further, if they should be audited, or if they're find themselves in a courtroom with their notes being scrutinized, you have to be able to do responsible clinical practice and give the evidence for what you say.
Yeah, absolutely. And again, just to hammer on this a little bit more, is I blame education training programs and I blame supervisors. When we look at the medical field, from what I understand from watching TV shows, they will have rounds and they will walk around with the resident, and there'll be the student essentially, and the more superior physician will be like, okay, what do we see? Okay, let's go through our assessment procedure. Okay, I see vomiting, I see red eyes, whatever it is. And okay, what's the conclusion? There's a process of observation, checking with the material, the research literature, or the diagnostic manuals, and then a conclusion, and then a treatment that follows that label. But in our field, it's a lot of just like, well, they have this, moving on, instead of going through the steps. And when I take my trainees through the steps, they get better at it.
Yeah. And proper diagnosis does call for those things. I mean,
Right.
each diagnosis has various symptoms and criteria that are required. And even going further, it's not just about whether the condition meets the criteria for the diagnosis itself, but then to do a differential diagnosis
Right.
where you have to consider, okay, it could be this, but what about something else? Are there other medical conditions, or are there other psychiatric conditions that would also meet those criteria? So a good diagnosis is a lengthy process. It's not just an intuitive process.
Right.
But, an intuitive process can help, but it has to be bolstered by the evidence.
Right. So were there other things that we didn't get to in the...
Yes. Also, I wanted to say that we talked about how sometimes counselors might be asked to provide a letter or some kind of commentary about whether a client would be a better parent or how they might see the client in a custody battle. Generally speaking, it's really best not to find yourself in the middle of that, and if anything, to only be factually based. But I just want to say that one way that a statement can be made, rather than saying, I think my client is a good parent, which you have no basis to say that on, because even if the client brought the child into the room, you're only seeing them under very limited conditions. But you could say, I've seen nothing inconsistent with good parenting. Or you could say, everything I've seen is consistent with what I understand to be good parenting, and to say what that is. But that's not a statement as to whether the person is a good parent. It's just that you haven't seen any flagrant behaviors that would defy that conclusion.
So if a treating therapist, family therapist, treating a divorcing mother and 2 kids were to come to therapy with 3, the 2 kids and the mom in therapy, and the therapist is treating, and the mom asks, hey, I'm going to court and there's a custody question, and I would like you to provide a statement that about my parenting, that I'm a good parent. That to say this person is a good parent, and particularly to say, I believe the husband to be a terrible parent. Obviously, that those are out of the scope, because one, you never assessed the father directly, and also you're biased because you're treating the family. But you can say a report that says something to the effect of, I have seen nothing that is outside. What was your phrasing again?
Well, nothing inconsistent with good parenting. Well, but first, that's under the most extreme of circumstances. If you're really forced to say something, which generally speaking, I think it's important not to be in that position, because you're teetering on a dual role. You're
Right.
teetering on going into that forensic piece. So you would be saying, the facts I've seen nothing inconsistent, or everything consistent with.
Right.
But really the best practice is to stay out of it.
Right.
Because what you always are risking is the therapeutic alliance, and you're risking, you really can't win. I mean, a therapist in a forensic setting, I would dare say, can't win. Because if nothing else, you're putting the therapeutic alliance on the table. The role of your client's attorney, who's supposedly on your client's side, not yours necessarily, but on your client's side, the role of that person is going to be to bolster the client. But there's going to be usually a cross-examination, and the role of that person will be to impeach you or to make you look bad, and to basically take your testimony and turn it inside out. So in favor of their client's needs. So my feeling is that you really can't win, and the best thing you can do is to stay out of it, and to explain to your client that it won't serve you to do that. If the language, I'm just saying that since you can't say the person's a good parent, and you can't say the person's a bad parent, and if they want something to that effect, you're not the one to give that. They need to hire an evaluator. They need to hire a parenting evaluator or have a psychological evaluation or something like that. But the most innocuous thing you might be able to say would be that I've seen nothing consistent with bad parenting, or I've seen nothing inconsistent with good parenting.
Under what circumstances would you be compelled to even provide a statement?
I would doubt that you would ever be compelled. I think the real strength is in learning how to evade that position.
Yeah. The thing I tell my supervisees, there are two things. One, you tell them that your supervisor won't allow you to do it because I won't. Just blame me. And two, it's unethical to provide that because of the dual role.
Right.
And if they need further explanation, I can provide them with material that actually explicitly states that.
Right. And I had one client who was on the stand at a hearing, and she was asked a question that was outside of her scope. And I had told her to simply say, that's outside of my scope of practice. And she then... But the attorney kept pushing, and I told her to turn to the judge and say, Your Honor, I'm here as a fact witness. I'm being asked an expert witness question, which is out of my scope of practice. Do you order me to answer this question? So put it in the lap of the judge. If the judge had ordered her, she might have answered it, but I would still maintain that she had no opinion in the forensic sense. She had no expert opinion because she was a fact witness. In that case, when she did that, the judge said what she said. The judge just agreed and did not order her to answer the question, and that was taken care of.
So are there any other things?
Yeah. So then we've got the question of the psychotherapy notes, which you asked about. So psychotherapy notes are explained by HIPAA as notes that are under the domain of the counselor, him or herself. It's for the use of the counselor, him or herself. But there are some criteria that must be observed. The main one is that the psychotherapy notes, to be psychotherapy notes, must be kept separate from the rest of the medical record. Now, in the old days, when people were using file cabinets, that meant that it should be in a separate file. It could be within the file cabinet, but a separate file. Now, people are very concerned because, of course, we have electronic files, but it should still be in some sort of a separate file, somehow separated. Even having said that, however, there are certain criteria that must be met in order to maintain the protections of a psychotherapy note. And one of those criteria is that the psychotherapy note should not include a diagnosis or include a summary of symptoms for the diagnosis. So before, when you asked about putting in a psychotherapy note, whether maybe there's a question of sexual abuse, that might be stated as a hypothesis, but if you begin to give the symptoms that make you think that, you border on whether or not that can be maintained as a psychotherapy note.
Because the courts or the law or the privilege or maybe has this notion or standard that everything that relates to the diagnosis and assessment is up for grabs when it comes for pulling the file?
I don't know if I'd put it that way. The way it states it in HIPAA, I'm reading from it, it says psychotherapy notes exclude medication, prescription, and monitoring, counseling session start and stop times, the modalities and frequencies of treatment furnished, results of clinical tests, and any summary of the following items: diagnosis, functional status, the treatment plan, symptoms, prognosis, and progress to date.
So basically everything that's supposed to be in the public file, the file available to the client and anyone who pulls it, should not. I mean, the way I would interpret that, because I've read that in the past, I interpreted that as saying, look, when you have diagnostic information, don't put it in the psychotherapy notes, put it in the file, but you can also have it in the psychotherapy notes.
Well, it says here, psychotherapy notes exclude.
So, but that seems to miss the point. I mean, of course, that's what it says, and I'm not arguing you're a better expert on evaluating that wording, but to me, when I read that years ago, I was like, it's saying, look, when you write this stuff down, if it's in one place, it should not be in the psychotherapy notes. That's not the place for it. It needs to be in the file available to the client because they need that information for medications and all that, that's relevant information. But if also in your psychotherapy notes you comment on it, obviously you're not going to have the systematic way necessarily the way you have in your progress notes that are available to the client and other physicians. But if you have comment on the details, like elaboration, like, someone has PTSD, for example, and in your the progress note, the file, the treatment plan you have, and the assessment you have that's available to the client, you have PTSD. Here are the symptoms as evidenced by blah, blah, blah. And then in your psychotherapy notes, you have like a really common example for my psychotherapy notes is I'm talking with a client about, because I'm doing, prolonged exposure therapy with them, and the diagnosis is PTSD. And in my psychotherapy notes, as they start working on their trauma narrative, I write down every detail of the sexual assault that they went through, because that's part of the model. They would not like those details to be in the progress notes if the insurance company were to pull it or if some legal thing happened. They don't want any of that story in there. Now, I guess I could say, you write it down and you take it home, and it's not in my psychotherapy notes, but it's much easier if it's in my office and I can look at it and have it in my own language and this kind of thing. So are you saying that according to HIPAA, and if the file was pulled and they knew about the psychotherapy notes, that they could also pull those psychotherapy notes?
Well, so this is an example of how I said at the beginning that I'm not giving legal advice, and that, and that everything is fact specific. So I would need to know, I would want to sit down with you. I would want to read the note and really look at that. I think in general, it's believed, although I've never seen it stated as such, it's believed that the psychotherapy note comes out of the kind of Freudian analytic tradition, where a counselor or an analyst might be really looking very strongly at their own countertransference and discussing transference and countertransference, which these days are not necessarily used for the notes that go to insurance companies. Insurance companies are really interested in the DSM or the ICD and the diagnosis and the symptoms that both render the diagnosis and flow from it. So I'm thinking more if, for instance, if you have a client and you're thinking, wow, this client really pushes my buttons. I find myself really not liking talking to this client. That would be something that could go into a psychotherapy note that could help you in your work with that client, because you'd be self-examining. You might take it to your own supervisor and discuss it, but it's not appropriate or needed for the insurance record. But what you're pointing out is the complexity of this issue of record keeping and documentation and how that should work. And I think it's still a kind of living thing that we all have to grapple with. And that's why we do ethics consultations. That's why, we didn't talk about this, but you were asking earlier about, do I enjoy looking at cases and seeing, and one of the things that I've been struck by, you'd think after a certain amount of time, you'd see the same story happen again. And I've never seen the same story happen. If it might be the same fact pattern on some broad level, somebody, if a counselor has sex with a client or with a former client, or if there's a scope of practice or a family law or a family counseling issue, but it's never quite the same dynamic. And so that's why everything really needs to be considered on its own, unto itself, sui generis.
Well, so you go by Fran?
Fran and Francis.
Okay. So Fran/Francis, thanks for coming on the podcast. Very valuable to me. I'll just say that. And I know to the listeners, because like we've been saying, there's a lot of misinformation out there. And even ethics instructors, continuing ed and in graduate school, aren't as close to the source or even near to the source as you are, and have a lot of misinformation and are spreading that misinformation. And it's really a disservice to us as a profession and to individuals. And so thanks for coming on the podcast. Again, give us your contact information.
So francesschopick.com, FrancesSchopick.com. I can be emailed at FS, that's F as in Francis and S as in Schopick, FS@francesschopick.com, or call me at 425-891-3411.
And you provide free consultation
up to about half an hour, and you can get questions answered and begin to decide if you feel comfortable speaking, and if there's something else I can help you with, I'd be happy to.
Yeah, very important.
Yeah.
Well, thanks, Fran, for coming on the podcast.
Thank you for having me.
We'll have you back on to talk about other kinds of things.
Okay, thank you.
And everyone out there, please take care of yourself because you deserve it. You really do.